Good afternoon. Thanks for joining us. Welcome to Plant Mooty's webinar on key considerations for the 2017 franchise registration renewal season. My name is Liz Dillon, and I'm a principal in the franchise group, and I'm based here in Minneapolis. I've been practicing franchise law for over 10 years, and I practice primarily in the area of domestic and international franchise law with a focus on regulatory compliance and other transactional matters. My co-presenter today is Erica Tokar, a rising star in our franchise group, and she is based out of Washington, D.C., and I will let Erica tell you a little bit more about herself.
Hi, thanks, Liz. Yes, my name is Erica Tokar, and I'm an associate attorney in GPM's Washington, D.C. office. Each year I'm involved in franchise registrations for roughly 30 brands, and I work with a very wide variety of franchisors, so ranging from restaurant franchises to equipment distribution to construction to real estate. I'm also involved in international franchise projects, helping U.S. franchisors expand internationally, and then also helping brands from abroad come to the United States. Lastly, I also devote a fairly significant amount of my time to mergers and acquisitions in the franchise space.
Erica actually flew in this morning from D.C. to join me in Minneapolis in person, and she is delighted that we're getting snow.
We don't have snow in D.C. We have rain. Wonderful.
A few logistics. We blocked off 60 minutes for this webinar, but we expect it to take about 45 minutes, and then we'll let you on your way. We won't be taking questions during the webinar, but our contact information is included on the PowerPoint, so please feel free to call us or email us after the webinar, and we would be happy to answer any questions or provide any additional clarification that you need. If anyone is having technical problems, please email Jim Shavey. His email is jim.schewe@gpmlaw.com. In addition, both Erica and I will be at the IFA convention in Vegas next week, so if you're planning on going and would like to meet in person, please let us know. As many of you on the webinar know, now is the time of year, the very fun time of year, when you gear up for franchise registration renewal season. Of course, franchisors must update their FDDs each year to comply with the FTC franchise rule and state laws. Also a great time of year to make other updates as well. For example, have you been faced with a situation recently where you wish your franchise agreement provided you with more flexibility, or where your franchise agreement didn't give you the protection you desired? Have you had a lot of pushback from prospective franchisees on certain provisions? Are there recent legal developments or cases that may impact your franchise agreement or the relationship with your franchisor? Are there problems in your franchise agreement that just don't work for your system or that just plain bug you? Now is the time to review those provisions and see where you can make improvements or even rephrase items to let your franchise agreement better serve you as a franchisor. So when we're talking about franchise registration renewal season, our goal is really threefold. It's ensuring that franchisors have prepared documents that comply with the law that will enable them to continue doing business in the coming year. 2, reading the cases, tracking the changes in the law, and ensuring that franchisors' documents reflect appropriate updates. And 3, considering what types of issues have come up within an individual franchise system during the past year or the past several years, and whether changes to the appropriate documents may strengthen the system going forward. Erica and I came up with this list of items that we want to discuss with you today: the proposed NASAA commentary on FPRs, joint employer, fine-tuning dispute resolution, technical filing issues, complex franchisee entities, insurance, data management and privacy, and record keeping. As most of you know, we have a large team of franchise lawyers, over 30 of them, and we're both transactional attorneys and litigators, and each year our team utilizes planning meetings to discuss key considerations for the year. We benefit from a diverse team, not just franchise lawyers, but specialists in other areas, as well as a diverse client base to inform our registration season considerations. So for this webinar, we tried to focus on issues that most franchisors are facing and provide some practical tips and examples to help you as you review your FDD and franchise agreement this registration renewal season. This list is obviously not exhaustive, and you likely will have other items on your list, but we hope this gives you a good start. In addition, we also considered adding to the list the recent changes to the SBA process and the SBA addenda, but Great Plant Mooty hosted a webinar on this topic last month, and it's available on our website if you wish to review it. We have broken up these list of items into two parts. First, our legal developments, and second, our system issues. In this section of the webinar, we are focusing on factors outside of your system that impact your franchise agreement. Throughout the year in our individual capacities and through our collaborations with our franchise team, we are always on the lookout for these. For example, we may consider how hot topics and headlines impact franchise systems, or think about cases that caught our eye in the GP memo. The first topic that we wanted to talk about is NASAA's proposed FPR commentary. The North American Securities Administrators Association, or NASAA, has issued commentary in the FTC rule over the years that franchisors can use as interpretive guides. Most recently, it issued a multi-unit commentary. After finalizing the multi-unit commentary, they had decided to take on the financial performance representations, or as I'll refer to them as FPRs. As many of you know, the FTC rule provides little guidance for franchisors providing FPRs, and the proposed NASAA FPR commentary is an attempt to provide more structure and guidance to franchisors. NASAA issued its initial proposed FPR commentary in October 2015. The initial comment period ended in November 2015, and after getting lots of feedback on the initial commentary, they released a revised commentary in September 2016, and the comment period on that second round ended in October 2016. In both these spaces, we assembled a team and submitted significant comments, so please feel free if you have any questions about the comment period or would like to see copies of our comments. And while the final commentary has not been issued, we suspect and have seen that some franchise examiners are already commenting on items addressed in the proposed NASAA commentary. And the proposed NASAA commentary will likely not materially change when the final commentary is issued. The proposed NASAA commentary is pretty complex, so for today we will hit on some of the key items that are likely to impact franchisors. The first item is that a franchisor with operational franchise outlets has no reasonable basis for making a gross sales FPR based solely on company-owned data. This is a change, as in the past, franchisors were able to make FPRs based solely on company-owned data, even if they're operational franchisees, provided that they had a reasonable basis. The FPR commentary, the pros commentary, has made it clear that there can't be a reasonable basis for this. Franchisors can continue to make FPRs based solely on company-owned outlets if there are no operational franchises. Another item from the proposed FPR commentary is the franchisor may make an FPR disclosing gross profit or net profit data based on company-owned outlet data alone, only if additional information is provided, including, quote, all actual and reasonable expected material, financial and operational differences between the company-owned outlets and operational franchise outlets, and gross sales data from any operational franchise outlets. Previously, franchisors were able to make an FPR disclosing gross profit or net profit of company-owned units without estimating or disclosing the exact differences, except to caution prospective franchisees that such differences existed. This type of information includes the impact of a royalty rate, marketing fees, cost savings due to multi-unit operations, and more. In addition to the restrictions, franchisors can now not, or won't, under the proposed commentary, cannot disclose this information unless the franchisors also make an FPR disclosing gross sales information from operational franchised outlets. Notably, if you make an FPR disclosing net profits based on company-owned data, you don't need to make an FPR disclosing net profits based on franchise data if you have disclosed the gross sales information from franchise outlets. Franchisors often don't have access to reliable information. Another item is that a franchisor may not merge data from both franchise outlets and company-owned outlets in a single FPR unless the franchisor has a small number of franchisees. We're presuming less than 10. Previously, you could merge data from both franchise and company-owned outlets. You know, it's very common to see, especially large systems with hundreds of outlets, include their, 10 to 20 company-owned outlets in their FPR. But many examiners have been requesting that franchisors separate franchise and company-owned information for the past couple of years. As a result, if you currently have an FPR that combines data of company-owned and franchise-owned outlets, you may want to consider separating the data this year. Another example from the proposed commentary is that a franchisor with 10 or fewer outlets may not base an FPR on a subset of these outlets. For example, if you want to disclose the performance of outlets operating for 3 years or more, you can only do that if you have more than 10 outlets. Finally, best performing outlets may not be included without disclosing the corresponding lowest performing outlets. For example, if you disclose the top 25% outlets, you must also disclose the bottom 25%. This commentary is complex, and it is long and it is detailed, and although the commentary will not be adopted until later this year and will include a phase-in period, as I previously mentioned, state franchise examiners may look to it for guidance during the 2017 renewal season. We are actually going to host a webinar solely on the FPR commentary on February 16th, and look for the invitation, and if you want more information on that, you can let us know.
All right, now I'd like to talk a little bit about joint employer liability. Now, perhaps the most talked about issue in the franchising space continues to be potential exposure to joint employer liability. So during the past few years, during franchise registration season, we have been reviewing clients' documents to ensure that appropriate language is included to help avoid potential mischaracterizations of the franchisor's relationships with franchisees' employees. A great place to start when reviewing documents would be the franchise disclosure document and the franchise agreement. So we're going to look at some sample provisions that should help minimize potential exposure to joint employer liability. So this first provision just sort of flatly states how the franchise relationship should be characterized. This is an example of a provision that could be utilized by most franchise systems, and it can stand alone. Two things that I like about this provision are, first, that it states that the franchisee will control and be solely responsible for day-to-day operation of the franchise business and the terms and conditions of employment. And then the other thing that it does is it includes a list of what that employment issue or sort of that employment space consists of. So soliciting, hiring, firing, disciplining, et cetera. I think it casts a fairly wide net. Another provision where you could consider making a change is the indemnification provision. Again, this is an example of a change that could be utilized by most franchise systems. Basically, this change just helps ensure that the franchisor is indemnified for claims relating to franchisees' employees. This provision highlights a drafting issue that I've discussed often with folks here from time to time, and that's whether to select broad but inclusive language or whether to state specifics. For instance, this provision indicates that the indemnification is very broad. So it covers activities related to the agreement, activities conducted under the agreement, or in connection with the franchise business. It's very broad. And then sort of in list form, it states a specific example. Another approach might be to incorporate an including but not limited to, if you wanted to add some additional specific examples of conduct that you'd like to be indemnified against as a franchisor. This next provision describes the function of the operations manual. So this is not the definition of the operations manual in the franchise agreement, sort of that capital M, manual defined term or that concept that's referred to throughout the franchise agreement. Rather, this is just a descriptive provision. This essentially does two things. First, it stresses that the operations manual contains both mandatory and suggested guidelines, and it also talks about, how the franchisor's guidance is tied to brand standards. The reason that we suggest including this is because if litigated in the context of a joint employer claim, it's possible that the franchisee will try to argue that requirements in the manuals are mandatory. But the reality is that for most franchisors, the manuals likely contain information that may not be technically required under the system. So the purpose of this provision is to help make it clear that not everything a franchisor tells a franchisee is mandatory. Now, Liz and I talk about this all the time and with our other colleagues and with our clients, that franchisors are really often walking a tightrope when it comes to giving advice to franchisees. One element that makes buying a franchise investment a strong investment, or can help, is that a franchisee is buying a turnkey system. So franchisees want advice, and franchisors typically want to provide that advice. But so the purpose of this language is just to reinforce that concept, to differentiate between mandatory and suggested guidelines, and then also when guidelines are mandatory, to tie them to the brand standards. All right, this suggested language here would go in item 11 of the FDD, where the franchisor talks about training. And again, the purpose of this language is to tie required guidance to brand standards and reinforce the idea that the franchisee is the sole employer of the franchisee's employees. Now, these provisions that I just spoke about are really sort of the low-hanging fruit in this space. They're provisions that can be dropped into your franchise agreement or your FDD by inside or outside counsel, but we also recommend taking your review to the next step. The first thing that would include is a review of the substance of the franchise agreement. So one of our jobs as outside counsel is to secure as much freedom and flexibility for our franchisor clients as possible. We typically try to draft the franchisor's rights under a franchise agreement broadly. This is particularly true for a startup system that doesn't have all of its procedures and practices in place when the franchise agreement is drafted. We want to make sure that the franchisor has the freedom to structure the system however they want. However, when you're looking at the franchise agreement with an eye to potential joint employer liability, if there are controls or potential controls that are built into the franchise agreement that the franchisor never intends to use, it may make sense to remove them. Additionally, internally, one concept that we have discussed quite a bit in recent years is strategies for keeping the definition of the manuals narrow. So most franchise agreements, as I mentioned before, have this capital M definition of the manual that's referred to throughout the franchise agreements. And several litigators on our team recommend that this definition be narrowly tailored, such that informal guidance, such as an email, is not considered to be part of the manuals. I mentioned earlier that I do a fair amount of mergers and acquisitions work in the franchise space, and I have seen definitions of manuals in franchise agreements that include virtually every piece of paper or oral advice even that the franchisor gives to the franchisee. I even saw one that specifically mentioned that receipts were included. And our opinion is generally that you're getting sort of into some shaky territory there when you are elevating every single piece of guidance given by a franchisor to a franchisee to the status of being included in the manual. In addition, we also recommend that franchisors review their manuals internally with some regularity, and also ask inside or outside counsel to review them from time to time to ensure that unnecessary controls are removed. Additionally, within the manuals themselves, we suggest that they specifically differentiate between guidance that is required versus what is suggested. Now, as I mentioned before, the first few provisions that I mentioned were sort of more straightforward and could be easily dropped in to franchise agreements or an FDD for a typical franchise system. What I'm talking about on this slide, though, these issues I think need to really be more carefully considered. So, when you're working with outside counsel or inside counsel, consider whether you update the manuals regularly to include all required guidance, or whether you could implement a system for doing so. Your system for providing information to franchisees will help inform how these changes should be made.
Thanks, Erica. Now we're going to move on to dispute resolution. And things franchisors should be doing this year to maybe fine-tune their dispute resolution provisions. We, as transactional lawyers, Erica and I consult with litigators on our team on a regular basis to stay abreast not only of recent precedents, but also what types of arguments are being asserted. As transactional lawyers, we're primarily concerned with what types of claims a franchisee might raise that could be a drain on a franchisor's time and resources, not only those claims that might be successful. And your dispute resolution provisions are like many back-end provisions in your franchise agreement, likely overlooked from year to year. This year, our litigators have raised several points in response to challenges they faced recently in litigating franchise agreements, and have made some suggested small changes to dispute resolution provisions to avoid the argument and the drain on resources. and your team may have faced similar challenges. Our first example of fine-tuning your dispute resolution provision is a very small change. In many dispute resolution provisions and franchise agreements, the franchisee agrees to reimburse a franchisor for all attorney's fees, costs, and expenses to enforce the franchise agreement. This year, we had a franchisee argue that the franchisor could not charge interest on such fees, costs, and expenses, as interest was not specifically described in the franchise agreement. Although it's a small change, we recommend specifically describing what interest a franchisor may collect to avoid an argument down the road. Another example relates to release language used in form agreements, such as assignment agreements, franchise agreement addenda, or mutual termination agreements. Standard release language generally includes the franchisor and its affiliates, officers, directors, agents assigned, and others. But recently we had a dispute on whether the release language applied to the franchisor's former officers or just its current officers. As a result, we recommend broadening the release language that you use routinely to include both past and present affiliates, officers, directors, agents assigned, and others. Related to the release language, if you offer an area development franchise, you may also want to consider this year requiring the franchisees enter into a release of claims as a condition for developing additional units under the area development agreement. Our final example relates to choice of law. We recommend that if you arbitrate, you specifically carve out franchisors' rights under the Federal Arbitration Act from the choice of law provision. Even though case law under the Federal Arbitration Act suggests that an arbitration provision will be unenforceable only where a party was fraudulently induced to enter into the arbitration provision itself, the law in some states is that a claim of fraudulent inducement essentially invalidates the whole contract, including the arbitration provision, regardless of whether the arbitration provision was procured by fraud. In other words, by not making it explicit that the Federal Arbitration Act applies, it could jeopardize the enforcement of an arbitration provision altogether. Well, most of you with arbitration provisions have added language to your franchise agreement over the years to prohibit consolidation of claims. This is also a good time of year to ensure that your franchise agreement does in fact require a franchisee's action to be conducted on an individual basis and not as a part of a consolidated or class basis. Finally, for those of you with arbitration clauses, now is a great time to review the American Arbitration Association's appellate rules and decide whether you want that as an option in your franchise agreement. Well, the appellate option is there. Both parties must agree to it, and if you want to ensure that you are able to use these rules, you should specifically mention the optional appellate arbitration rules in your franchise agreement. This option may be most appropriate if only one arbitrator is selected instead of a panel of arbitrators to conduct the initial arbitration. Eric is going to talk about some technical filing issues next.
Yeah, if you will indulge me for just a moment, I'm going to get into the weeds. The last of the legal developments that we'd like to touch on is technical filing issues. So as many of you know, Hawaii increased its fee this year. I think that's worth noting. Additionally, there are a few kind of timing issues that we wanted to touch on. These are just trends that we are noticing in the various states. So the first of those is that states like Virginia are issuing comment letters and in many cases will not accept a certification from the franchisor that is dated before the financial statements or before the issuance date of the FDD. And of course the certification is the document that the franchisor signs, standalone document that essentially certifies to the accuracy of the FDD. Now, conceptually, that makes sense because that certification relates to the completed FDD, and the FDD is not complete until the financial statements are issued. Anyways, that's sort of just something to keep in mind. Additionally, you know, one of the things that we always work with our clients to do is to manage dark periods. States like New York and Virginia continue to experience long delays. Minnesota was also backlogged last year. Of course, there's not much that we can do about this, you know, other than advocate with examiners on a case-by-case basis, you know, and as a group. But we do anticipate these delays, and we also keep them in mind when we're working with clients in terms of how to be strategic about impending sales. A couple other issues actually that Liz and I were just talking about before we started that I'll mention. One of these isn't really new, but it's a growing trend, and that's electronic filing. There's electronic filing in some form or fashion now in Minnesota, Rhode Island, Washington, California, Utah, Florida, and now Wisconsin. And it's actually required in Wisconsin this year for the first time. All of those states have some sort of online filing portal, and then Florida, just sort of has an email procedure. But some form or fashion, we have electronic filing in really a lot of states these days. Another issue that Liz and I were talking about earlier is has to do with franchise brokers. And the situation emerges often where you may not be able to indicate exactly which individual within a broker network will be offering franchises in a particular state. You're working with a network, a group of brokers, and you're not always able to identify, which individual is going to be operating in that state. And so states sort of treat this in different ways. Some states don't want a stack of broker forms, like California and Illinois. So what we do from time to time is that we'll ask clients to tell us when they have a lead in that particular state, and that's when we'll file a broker authorization form. Other states, and particularly I'm thinking of Washington, have asked for essentially the opposite. Brokers have to register in Washington, and we've heard from examiners that they would like every single individual who could sell a franchise on behalf of a broker, they would like a broker authorization form and a broker registration for all of those individuals within the broker network, which can also be onerous. So these are just a few things to keep in mind if you're planning to use brokers, and the suggestion would be that you work internally or work with your outside counsel to develop a strategy.
Great. So that was part one. The second part we're going to talk about is systems-specific issues. Instead of looking at changes made in response to state agencies or cases we've had, we wanted to review issues that you may consider reviewing internally this year. And you should be asking yourself, what issues have arisen within the franchise system during the past several years? What kind of issues do you see arising in the future? And does your franchise agreement provide you with a foundation that you need to address them? For example, do you want to implement a significant system change down the road? And if so, does your franchise agreement language allow you to easily make the change? Or maybe there is constant confusion over a certain provision. This is the time you want to review, and you'll want to get feedback from your sales team, your compliance team, your executive team, your franchise support team, and looking at what changes really do need to be made. One issue that we wanted to touch on today that we feel we're getting more and more questions on these days is complex franchisee entities. Rather than a couple, an individual, or even a small group of investors purchasing one franchise or two, much larger entities such as private equity are now investing in groups of one or multiple franchises. In addition, franchisees are becoming more sophisticated in their estate planning and are using trust to own the franchisee entity rather than owning it directly. These sophisticated franchisee entity issues arise, and these franchisee entities are often unwilling or unable to provide you with the same consideration and security as a standard franchisee would, including providing personal guarantees. And as franchisors, it really doesn't make sense to simply refuse to modify your franchise agreement when these situations arise. So if you're getting more and more requests for these types of structures, it likely makes sense to create a form addenda or modify the franchise agreement to address the biggest concern for franchisors. The key considerations that we review are listed on the slide. First is control. Whether it's private equity or trust owning a franchise entity, a key concern for franchisors is understanding who is going to control the franchisee entity and what happens if that person is no longer with the franchisee entity. In addition, the franchisor needs to understand who is responsible for making the day-to-day operational decisions respecting the franchise and who the franchisor should be communicating with. The franchisor doesn't want to end up in a situation where it doesn't know who it should be sending communications to and who can authorize something on behalf of the franchisee entity. And we'll get to the next slide in a moment, but it gives a good example provision that addresses operational control, at least within a trust situation. The second consideration here is the transfer. A standard transfer provision in a franchise agreement may not expressly address these sophisticated entities. For example, what happens if a trustee or beneficiaries of a trust changes, or if key management leaves the entities? These changes should trigger a change in control that would require a franchisor to approve the change, just like any other transfer. A next consideration is the personal guarantee. As I mentioned before, private equity and trusts are usually unwilling or unable to provide a personal guarantee. So the question is, how do you get financial assurances from the franchisee entity? Do you have the trustees sign a personal guarantee? Do you get a corporate guarantee? Do you get a letter of credit? You could require a franchisee entity to maintain a certain amount of equity and monitor that. There's a lot of options out there, but what is required to make any individual franchisor feel comfortable with the prospect will vary in each instant and vary with each prospect. But this is an item that should be carefully reviewed. Another item to consider is confidentiality. If certain key individuals involved in the franchisee entity haven't signed a personal guarantee, you will want to be sure that they sign a confidentiality agreement and possibly non-compete with you. In addition, you want to prohibit sharing of confidential information with others. For example, a trustee should not be sharing confidential information with a trust beneficiary, even though the trust itself may own an ownership interest in the franchisee entity. You'll also have to look carefully at the non-compete situation. You might need to get a non-compete from individuals involved in the franchisee entity that maybe haven't signed a personal guarantee but are key individuals. Or you may be asked, especially with private equity, to modify the non-compete to more narrowly tailor it in order to reflect their existing business interests. In a trust situation, you should also consider getting representations from the franchisee entity, the guarantors and the trust, that one or both the guarantors or the trust sole trustees, and these roles aren't assignable under the trust documents, and one or both of the guarantors are the only individuals authorized to vote for the trust shares in the franchisee entity. While I talked about creating a form addenda to address these issues, many of the issues can also be addressed in the franchise agreement itself, particularly if this is common for your system. For example, you can review the definition of change in control in the franchise agreement to address operational control that would trigger a transfer. The next slide is the example that I talked about previously that talks about operational control in a trust and who will be controlling the franchisee entity and what happens when if that person is no longer controlling the franchisee entity and the requirement that they apply or comply with the transfer provisions and get your consent.
All right, insurance. My sense is that here at GPM we talk about insurance more than I think maybe your typical franchise firm might, probably because we have some stellar attorneys here, Nick Nierengarten and others that always keep us kind of in the know. So just a few tips for when you're reviewing the provisions of your franchise agreement that relate to insurance. One thing that we recommend is that the franchise agreement, the manuals, et cetera, require a franchisee to obtain not less than a certain amount of coverage. This ensures that the franchisor can benefit from the full coverage that the franchisee obtains in the event that the franchisee obtains more than what the franchisor technically requires. Another tip is, or one thing that several franchisors sometimes learn the hard way, is that the certificate of insurance is a document that is issued by an insurance broker, not the insurance carrier, and it is not binding. And we have seen situations where an insurance company has tried to deny coverage when a franchisor was listed on a certificate of insurance but not on the actual policy. So in addition to the certificate of insurance, many franchisors require franchisees to submit a copy of the insurance policy itself or the endorsement as evidence of coverage. Another recommendation is to consider new policies that you may want franchisees to acquire. For instance, some franchisors are now requiring cyber liability insurance. And I think this is a great example of why it's a good idea to review your insurance requirements each year, because this didn't exist, more than a handful of years ago. It's still an evolving area of insurance, so there isn't one set policy. But if you think that requiring cyber liability coverage may benefit your system, you could discuss some specific options with your insurance broker or with your franchise attorney. We also encourage clients to carefully consider the scope of the coverage. For instance, foodborne illness is not covered by a comprehensive general liability policy, and that is an important detail, for instance, for a restaurant franchisor to be cognizant of. We also recommend that the portion of the franchisor's manual that addresses required insurance be drafted by an insurance broker so that franchisees can take that exact language to their broker and ensure that they are ensure that they're obtaining the right coverage. This next slide just includes a franchise agreement provision that accomplishes two of the things we just discussed. It requires the franchisee to obtain not less than a certain amount of coverage, and it also requires the franchisee to provide evidence of coverage that is beyond just a certificate of insurance.
Thanks, Erica. Now we're going to move on to data management and data privacy. Data privacy continues to be a hot topic, not just in franchising, but really across all industries, and is continuously in the news. And while we have seen some highly publicized data breaches with large franchisors, it also happens in small systems. As a result, it's extremely important that your system, whatever the size, stay on top of these matters and ensure that you've taken all steps necessary to protect your system. Most franchisors will unfortunately be subject to a data breach at some point in time, and the more prepared you are, the better you can contain the problem. Our first recommendation is that you are up to date on PCI compliance. It's kind of a constantly evolving area, and you need to understand what that means and make sure that your franchisees understand what that means. You should also have provisions in your franchise agreement and manual requiring franchisees to be PCI compliant. You may also want to consider requiring that your franchisees go through PCI compliance audits periodically and have that part of your agreement. Another issue that's come up since 2015 is that there is increased potential liability for if your franchisees are not equipped with chip readers for their credit card machines. So if your franchisees have not adopted the chip technology, the liability for fraud and certain other claims actually shifts from the credit card issuer being primarily responsible to the fraud to the actual merchant being responsible for the fraud. So not only should franchisors be requiring franchisees to implement the chip technology, but they should make sure it actually is happening and push it along. Fraud at any location reflects poorly on the brand. In connection with these type of technology advancements, you should make sure that your franchise agreements allow you to implement and require new technology over the term of the agreement through the POS system or any other types of technology, so that when it is introduced, either because you want to change something internally or in response to things like the chip technology, you have no limit on your ability to make that change in your system. The next point is a data breach response plan. This is an absolute must for franchisors. If you don't have one, you should be creating one. This plan is crucial to ensuring that you're able to respond quickly and effectively if and when there is a data breach. But it really isn't enough to just simply craft a plan or find one out there and kind of modify it for your system. You need to make sure that it would actually be able to work in practice and that franchisees understand how to do it. And you might even have to provide training to your franchisees on how to respond to a data breach. There was a data breach at a large franchisor a couple years ago. And in the system, not all the franchisees were operating under the same POS system. A lot of the older legacy franchisees had a much older system or systems that weren't on line with the franchisor. And so when the franchisor became aware of the data breach, while they were able to shut down systems or franchisees that were operating under their newer POS system, franchisees under the old system weren't able to and didn't understand how to effectively shut it down. So the data breach went on for days after the franchisor was aware of it, just because they weren't able to effectively get all those systems shut down and stopped. In addition, we recommend that you have a provision in your franchise agreement that requires all your franchisees to comply with any data breach response plan that you have in place and to notify you immediately if they suspect a data breach. It's also a good time to review your privacy policies and ensure that your franchise agreement requires franchisees to comply with any privacy policies. Often these policies were originally put together a decade or more ago and don't reflect current practice. And it's important that whatever you're doing with customer data and how you protect is accurately reflected in the policies, or it may expose you, the system, and your franchisees to some risk. Finally, it's a good time to step back and determine who does and who should own customer data. At one time, I think franchisors were all wanting to own all customer data, whether they really needed to or not. And certainly in some systems, customer data is vital to the business. For example, a service business where you're providing services at someone's home, the customer data really is the biggest, most important part of the business. And in those cases, franchisors will want to own that customer data and are willing to take the risks and responsibilities that come with that data control and ownership. But in other systems, customer data may not be as important. And franchisors may decide they don't want access to that customer data or ownership of the data and would rather let the franchisee be responsible and bear that risk. This is a conversation you guys should be having internally during this renewal season, making sure that you understand who owns it and who should own it, and then reviewing your franchise agreements to make sure that the provisions respecting customer data ownership reflect your team's desires. And we've included a couple example provisions here that you can look at as you're reviewing your franchise agreements this year. In this first example, we've provided some language about a franchisee's responsibility to keep its own system secure. While a franchisor will likely step in and control if there are any security issues, it does put some burden on the franchisee to maintain a secure system, and provides the franchisor with some language that it can point to if it feels like the franchisee is not maintaining the integrity of its system. We have another example here that relates about compliance with the franchisor's privacy policies and data protection. And it also requires franchisee to notify the franchisor if there is a suspected breach. Again, this provides franchisors with guidance and something in the agreement that they can point to if they're trying to get a franchisee to comply with the data breach response, which may cost the franchisee time and money.
All right, last but not least, record keeping. Perhaps not the jazziest topic, but still very salient during renewal season. When you're looking to update and refine your franchise agreement during registration renewal season, you may want to take time to ensure that your franchise agreement enables you to collect the different types of documents that you may need. So, for instance, in addition to having the right to conduct an audit or an inspection, we often recommend that franchise agreements give franchisors the right to require that franchisees send them copies of documents. Copies of documents may be all the franchisor needs, and requiring that franchisees send them to the franchisor can save both the franchisor and the franchisee time and travel, and also save the expense of a full-blown audit. I'm surprised at how many franchise agreements don't specifically address this. You may also want the right to request records not only for the franchisee entity, but also for principal owners. The big reason for that is that reviewing principal's tax returns can be a really great way to target underreporting of gross sales, and forensic accountants can review these returns quickly and efficiently to get information and detect issues. Our litigators have delved into this, countless times. Of course, collecting these documents is only useful if there is someone on your team to review them. So now may be a good time to consider the record-keeping system that you have in place. Some clients that I work with use checklists or other tools to ensure that the documents are actually being collected. And if you're not collecting the documents you need, sending a new day letter may be a great way to reset expectations within the system. I can attest firsthand to the value or to how keeping good records can contribute to the value of the franchise system. As I mentioned earlier, do a fair amount of mergers and acquisitions work in the franchise space, and record keeping is critical for due diligence review when systems are acquired. That's why at Expos, when we're talking to prospective franchisors or working with startup franchisors, we emphasize that contract administration is a place where franchisors should invest time up front to establish good file hygiene. Additionally, established franchisors can also benefit from taking a hard look at their practices. Often the emphasis of the scrutiny and an M&A look back is often only a few years, or it focuses on the highest grossing or multi-unit franchisees. So even a system that may not have observed the best file hygiene practices in the early days can set up an infrastructure now. Now is always a good time to implement a good contract administration system. This next slide just provides an example of a franchise agreement provision that will enable the franchisor to collect the principal's tax returns. And this last one enables the franchisor to request copies of records and in addition have the right to examine or audit them. So particularly with regard to record keeping or really any of the topics that we've covered today, now is a great time to put new tools or procedures into place that will benefit the system. So I think we're starting to wrap up. Once you have started looking at your franchise registration renewal process through this holistic lens, please contact Liz or I with any questions. As we mentioned, we will be at the IFA this weekend. And additionally, thank you for joining us. GPM's franchise and distribution team will be hosting webinars quarterly. The next one will be February 16th with Diana Villeneuve and Max Schott. So don't forget to sign up. Thank you.
Thank you. Have a great day.